This is a de novo appeal. I filed it on October 14, 2025 from a justice court decision regarding a residential lease. However, the core of this dispute is incredibly simple. It is about a $4,000 security deposit. The delay in returning the deposit was not due to malice or dishonesty, but due to a communication failure by third party. I have not received a direct forwarding address or the move out documentation at that time. I'm asking the court to grant the motion today because plaintiffs have zero evidence to support their claims of bad faith or their newly amended claim for breach of contract. And their entire case relies on a demonstrably false affidavit. If I may a little bit further explain, at a very high level. First, all this is documented in my filings since October. First, regarding the forwarding address under the Texas Property Code 92.107 and our lease agreement, providing a forwarding address is a conditional precedent. Landlord is not obligated to return a deposit until the address is provided. Plaintiffs never provided their address directly to me. Maybe they relied solely on the text message to former property manager. However, as shown in my filings, Mr. Auberg, who is the property manager, texted plaintiff who they were in contact with. It's quoted as question for her. We never had it in first place. She took over. So because that the condition precedent was never met, there is no breach of contract. In fact, the plaintiffs never shared their address with me until I received a notice from the JP court that they had sued me for $12,000 back in August 9, 2024. Second, regarding bad faith claim, I actually tendered a full $4,000 security deposit to the plaintiff in November 2025 to resolve this, right after I filed my appeal and in communication for settlement with the plaintiffs. They actively rejected the check. Texas law does not reward plaintiffs who refuse full payment of a debt payment just to drive up litigation costs and gamble on treble damages. Finally, Your Honor, regarding the plaintiff's evidence, which was submitted in the documentation by the plaintiffs, to survive this summary judgment, plaintiffs submitted a sworn affidavit last week claiming they never received my $4,000 check. This is perjury, I feel. And as shown in my Exhibit 1 to the response, Mr. Gilbert sent me an email on November 11th, 2025, stating, again in quotation, we have reviewed your filing and noted the 4,000 check. We do not accept 4,000 as a settlement. A party cannot create a fake fact dispute to survive summary judgment by submitting a sham affidavit that directly contradicts their own written emails. Because the full $4,000 were tendered and rejected, because they have failed me to provide a forwarding address back then, and because their affidavit is sham, I respectfully request the court to grant my no evidence motion for summary judgment.
Thank you very much. Ms. Safford.
Good morning, Your Honor.
Good morning.
Just to put this into context, this is a no evidence motion for summary judgment. The movant hasn't, she didn't attach any evidence to her motion. She did a response to a reply that had to be corrected because she had a false affidavit, a false piece of evidence in there and that she corrected, but it's really based on our evidence. That's the whole idea of a motion for summary judgment, is not to get into a no evidence motion for summary judgment, is we don't get into these swearing matches. You look to the evidence that we put forth in the reply and you decide if it's enough evidence to support the issue. Her motion is not on the claim. Her motion is on one of the issues involved in the security deposit fight, and that is whether there's bad faith to justify the treble damages under the statute. Bad faith is not just late filing, late return of the security deposit. The court can find bad faith for a number of different reasons. It's presumed if the itemization and the return of the security deposit isn't returned within 30 days, but that's not the sole basis for finding bad faith. She seems to be arguing mainly that she was not untimely with the return of the security deposit because there wasn't a timely forwarding address. That seems to be the big part of her argument. But there is ample evidence in this case that's in our summary judgment evidence to support the concept that the movement acted in bad faith. And it starts with this. She had and this is all in our summary judgment evidence. She had a property manager handling the move out issues. Thus, the forwarding address was provided to the property manager. 3 days after it was provided, she fired the property manager in there. 30 days goes by. Oh, and by the way, the property manager, it's in writing, said the property was left in great condition. They did an amazing job of repainting and fixing it up, and that it was in very good condition. That is in the summary judgment evidence. 30 days goes by, and the Gilberts write to her and say, hey, we didn't get the security deposit return. She sends back to their new address within a matter of days. She sends back to them an itemized statement and none of the money. The itemized statement has charges that in our summary judgment evidence we say is bogus and contradicts her own property managers on the ground inspection. You may recall in open court, the movement said she hadn't been back to the property and back to Austin in 2 years. She never saw what was there. She fired the property management, turned back an itemization, had no evidence to support it. None whatsoever to support, and we say these are all bogus charges. As a result of that, the lawsuit was filed in JP court. She answered the suit not with it was just timely or I have all these charges, but she said there's no security deposit. She denied there even being a security deposit on this. After she lost at JP court, after the JP court found that there was bad faith on there, she writes a letter and sends him an email that she's going to send the $4,000 to them. Our client emailed back and said, look, I mean, they were sitting on a judgment with $12,000. $4,000 to settle this claim isn't enough, but they never get the check. They put in summary judgment that she never sent the check. And I have told her this many times. We never got the check. The clients never received the check. So she says in her motion, but no real summary judgment evidence, I sent them a check. But their testimony, that is what you have to rely on, says she never sent the check on there. Now she seems to be saying in the appeal, I understand that I owe them the $4,000, but I've sent them the $4,000. After the judgment was for approximately $12,000 in the JP court. There is ample evidence to set this to the fact finder, whether that's you or whether it's a jury, to sit there and say that the movement acted in bad faith. Bad faith is inherently a fact issue. It's not a legal issue. And based on the summary judgment evidence that we've put forth, there is ample evidence of bad faith. Now, I did make a motion, I did make an objection to the fact that if you feel there's not enough evidence, and Judge, I feel there's more than enough evidence for a finding of bad faith. But the movement has denied me the opportunity to take her deposition before this. If you recall, we had a hearing about Zoom, went to do Zoom, and it was ordered that she should appear. I begged her for dates before I had to file a response to give me a deposition date, and she would not give me a deposition date until after March. I don't want to waste until after this hearing. She said, let's have this. She wouldn't give me a date to come to Austin to do her deposition. I had to file my response. I filed my response. I made the objection. I don't really want to waste the court's time on this issue. I think there's absolutely enough evidence to have a finder of fact decide whether there's bad faith on there or not. We're gonna have a trial anyway on the $4,000 and attorney's fees and all that. And the issue of bad faith should be decided at that time based on the evidence. I know she doesn't believe the evidence. She thinks she has evidence to contradict that, but that's not resolved in a no evidence motion for summary judgment. And we would ask that the court deny her motion.
All right. Thank y'all very much. Anything else? No?
Your Honor, it's fine.
Yes?
Okay.
Yes, go ahead.
So, Your Honor, my no evidence summary judgment, I have clearly attached in my timeline chronological order and also rebuttal. And not just these 4 or 5 points in bad faith, especially for bad faith. I have been filing all my responses on time as I received the documents, and I have provided all my backing and explanation over last 4 months. And today I'm hearing is that it's again for bad faith and that I have denied security deposit and I have not been collaborative in responding to Mr. Mitchell. These are the things I'm hearing, but I want to again explain from my end.
Ma'am, please understand, this is not, the only thing the court considers is what's on file that was
Yes.
filed in this part of the case.
Correct.
So you telling me other items, it's not evidence in front of me, okay?
Yes.
There's nothing, you can only go with either arguing what you filed, or if you've somehow filed something else in response to him, okay? Because that's the only thing that in a summary judgment motion, that's the only thing a higher court would look at is whatever, there's no record, it's just what's filed, okay?
Yes, yes.
Okay.
I'm just pointing out to what I have already filed. And I have filed all the exhibits due as my response. And as
Ma'am, please just get to your argument so I can finish this hearing today, okay?
Okay.
Thank you.
So my argument here is that one second, I'm just looking at my notes. So my plain argument is that please grant the motion for no evidence summary. And since it is about the security deposit, which I have tried to give back, and I am trying to please help me with close the case and help me provide me the closing the no evidence motion for summary judgment. And my entire argument is order that plaintiff take nothing, no attorney charges, no other things other than just the security deposit.
Thank you, ma'am. I appreciate that. Mr. Saverick, anything else?
Judge, no, I think, like I said, in our summary judgment, our affidavit are attached, the emails, everything we have. We believe there is ample evidence, not only to get over the hump of her motion, but to actually establish bad faith in this case, which is what the JP court decided.
All right, thank you very much. I appreciate the motion from Ms. Bogerloo and also the response. In a no evidence motion for summary judgment, if there's some evidence at all, those are denied. And in this case, because of what I'm looking at here, I'm going to deny the no evidence motion for summary judgment. I'm going to urge the parties to follow my prior rulings about getting this deposition done timely. If it's not done timely and there's a follow-up motion on it, I will consider other acts that the court can do to enforce these things. I don't want to have to do that. This is a pretty simple matter. Get it done so we can get it tried either before me or Judge Shepard or trial before a jury. But let's get this done, okay? Y'all shouldn't be tied up in this very long. I don't. When I see these cases, I take a second look at it, kind of going, why is this taking so long? And why are they arguing about so many things when it's a pretty simple matter? Both sides, tell your clients and the party here, do not be stubborn about this thing. Try to work it out, okay? If you can't, you may not be happy with the results if you're letting a jury decide or you let a judge decide. So if y'all can work it out, great. If you can't, I'm happy to do my job, and I'm sure a jury would be happy to do their job too. All right, thank y'all. Ms. Saverick, I need an order saying the motion's denied.
We downloaded one both in the box and in the system.
Okay, thank you very much. We'll take care of that. I wish y'all well. Continue to talk. Try to be open to trying to get things taken care of. Thank y'all very much. Y'all
Thank
are
you, Judge.
excused.
Thank you.